King, there's a lot of suckers out here with their money, and you can't be no sucker out here with your money.
Bro, I ain't no sucker. Bet you I don't.
Okay. What's assets?
Assets are things that bring money into your bank account.
What's liabilities?
Liabilities are things that take money out your bank account.
Entrepreneurship is the act of becoming an entrepreneur. What's entrepreneurship?
Entrepreneurship is a process of setting up a business or businesses.
Taking on a greater than normal
Financial risk.
What's an entrepreneur?
Entrepreneur is a person that organizes and operates a business or businesses.
Also taking on a greater than normal
Financial risk.
What's financial mean?
Money.
And what's risk mean?
Chance.
Come on. What does it mean to own stock?
When you own a share of a company.
Come on. What's real estate investing?
Real estate investing is when you invest in a immovable property.
What's the two types of real estates?
Commercial real estate and residential real estate.
What's commercial real estate?
Commercial real estate is property for businesses and workspace, like an office, store, or land.
And what's residential real estate?
Property to live on, like a house, apartment, or condominium.
Come on. It comes with extra fees when you have real estate, you feel me?
Mm-hmm.
Daddy tells you how many times he pays his state property tax a year.
Once a year.
What's the type of maintenance fee?
Cutting grass.
Come on. What's HOA?
Homeowner association.
And what comes along with that?
HOA fee.
Come on. And when it comes to the brokerage percent, what percent is that?
7.
Come on. What's equity?
Equity is the difference between what your business is worth minus what you owe on it.
Also assets minus
liabilities and debt.
Good job. What's credit report?
Credit report is like a report card letting you know how well you did by paying your money back you borrowed.
And how does credit affect your life?
The better you keep your credit, the more opportunities you'll have to get funding.
And what? Large purchases like?
A car or a house.
Come on. And always repay what you
owe.
Because if you owe somebody, that means you're in
debt.
And you never want to be in
debt.
Because that means you
owe somebody.
And we don't never owe
somebody.
Because that ain't what suckers do, period. Come on.
Yeah, man.
Good afternoon and welcome back to Your Money Matters. Once again, it is Women's Week. We have pushed George Demery out of the way so we can talk about some things that are relevant to women. Today, I have an attorney with us because there are so many things that women need to know about legal matters. We have Patience Fitzpatrick, and I'm going to let her introduce herself and tell you a little bit about her.
Well, hello, I'm Patience Fitzpatrick. I am an attorney in the Louisville area. I practice in several different communities, but primarily in the Jefferson County community. I primarily focus on family law, estate planning, and probate, and some minor criminal things like traffic infractions, things of that nature. I've been an attorney for 10 years, and it's been a very rewarding time for me. I like helping people with their legal issues, and it just allows me to also take part in helping the community and getting out there and guiding people on what they can do to kind of better their own lives.
Because she specializes in family law and estate planning and wills, guess what we're going to talk about today? And we're just going to jump right in. Many people are familiar with the term will, but there are many people who don't have a will. And I want to start off because that's something that we're all familiar with. Patience, can you share with us what is a will and why do we need it?
Mm-hmm. A will is your last will and testament. Just put plainly, it is the document that dictates how your stuff will be distributed, who's going to get your things. It's important because we all work so hard every day to make money and to provide for our family and loved ones, and to pass away without having something in place that allows people to know how you wanted your things given out or who you want that to go to is heartbreaking sometimes. So it is important, no matter what you have or do not have or what you believe you do not have, it is important to have a will in place because that is the only document that dictates whether or not your husband gets something, your children, or your best friend, Mary, gets it. Otherwise, if you do not have a will in place, essentially the state makes one for you, And they don't sit and draft one, physically, but by the laws of the state of Kentucky, there is a list of how the things are going to be distributed, whether it goes to a spouse or a husband, a spouse or children. So if you want it to go to someone particular, then you want to have your will.
So a lot of people think, I don't own a home, I don't really have a lot of furniture.
Right.
Why do I need to spend money on a will? Can you give me an example of, because it's women, let's focus on women. So let's say there's a single mom, and she may have, let's say she has 3 kids. And in today's society with blended families, they may have a different father. So why would it be important, even though they may not think that they have a lot of assets, but they do have children, why would that be important for them?
First of all, regardless of how many assets we have or believe we do not have, you still have stuff. Whether it's furniture or money, you still have it, and somebody has to deal with that. So you want to take the burden of somebody having to choose who's going to deal with that, and then you deciding how those things are going to be taken care of. The other part of that is your children. And you want to, within your will, you can create a trust in your will that determines or dictates how the money that you do have in your estate, how that will be distributed to your children. You can also put like a guardianship provider in that will that allows the court to know who you would want your children to remain with once you're gone. Now, keep in mind, in the state of Kentucky, the courts are always going to, go by a best interest standard, and that may be a parent. Even if the parent didn't raise the child, essentially that parent would still have some rights or some say-so to say, hey, I would like to take him or her. But at least if you, put in a will that, hey, I would like my child to go to my best friend or my mother, then it gives the court some guidance to go, well, I wonder why they don't want the child, the child to go
with
to dad.
There
and
might
that
be
gives
some
a little
things
bit, right, and then that allows them to do a little bit more digging,
So how powerful is that will? I mean, let's say there is some discrepancies, and does it have to be signed? Can you do your own will? Do you have to have an attorney do your will?
Well, I mean, there are, a list of requirements to have a valid will in Kentucky. So, of course, your will have to be signed and notarized with witnesses. That is the most important thing, I think, to make sure that, one, you're signing it, and that, two, that you have at least 2 witnesses, and it's notarized. That lets the court know that, this was, you're speaking to them to let them know what it is you wanted to have done with your estate. You can write your own will. It's called a holographic will, but you still want to have some of the same requirements. You want, so if you're going to write your will, you're sitting at home and writing it, I still would sign it.
You mean just on a piece of paper,
paper.
Like this tablet right here?
Yes, ma'am. Write it down on a piece of paper, what you want. Make sure that you're saying you're of sound mind and body, because you have to be of sound mind and body and over 18. And then make sure you can sign it. And then if you can, you want to have it notarized if you can. You want to have some witnesses if you can. That way, although you wrote it yourself, it lets the court know, again, you were serious. And that you took the steps to make sure that your will would be valid in Kentucky.
So here's my will. I got it. I've already got it on a piece of paper. Now, what do I do with it? I got to put it somewhere. Do I get a lockbox at the bank? Do I give it to my sister?
No. Well, you can give it to, of course you want to give it, you can either put it in a safe place in your own home, in a lockbox, something fireproof, something safe. You can give it to a loved one to keep for safekeeping, but you don't want to take it to a bank and put it in a safe deposit box. Because you have to go through the probate process in order to get your will, entered into probate and looked at. And if it's in a lockbox in a bank, the bank can't let you in until the court says you are the appropriate person to look at it. And so you have to go to court first to have that happen. So your will is essentially in a bank that no one can look at it. You also have to submit that will to the court for probate. You can't do it if you can't get it out of the lockbox. So it's just kind of a thing where it's just not a good place for it. It used to be. People used to do that all the time. But unless you have the key, unless the person that you have left has a key and then there's another key, then I would not.
Which I just turned in my keys to my lockbox because it's been empty for years.
Oh my goodness, yes.
So, you have talked about probate. And a lot of people hear that, but people really may not understand what exactly is probate. What does that mean?
The probate process allows you to take title to certain property. You know, a lot of times people will pass away and they may just have a sister, and then there's just furniture in the house. You know,
Right.
maybe they have money in their pockets, things like that. A lot of times people won't go through the full probate process, and there's different, you know, levels of probate. But so sometimes people won't do that. But where you have a house or a car, you know, stocks, bonds, things like that, there's title involved. And the only way that you can actually become the owner of that property is if the court says that you can become the owner. So you have to present your estate or that person's descendant's estate to probate, so that the court can then take the task of seeing who is the appropriate person to wind up the estate, who's the
Okay.
appropriate person to inherit, and things like that.
So the most recent thing that I came across in my line of business is there was a client who passed away. She had a beneficiary on her life insurance policy and her retirement account. But the beneficiary passed away 5 months ago.
Okay.
And she did not have an opportunity to change the beneficiary.
Okay.
Now she's passed away and there's no successor. So what happens, and her family cannot find a will.
Okay.
So what happens to her things?
Well, essentially with that, you said it was life insurance?
Life insurance and a retirement account.
Returned. Okay. So essentially when you have life insurance or when you have any type of retirement account, you want to, you know, make sure you have a beneficiary, but then
Right.
you also want to have a backup. So you want to have a successor for that very reason. Because what happens is when you pass away, those funds go automatically to the person that you've chosen. They don't have to go through the hassle of probate. They don't have to ask the court for permission.
If you have a will.
If you have, no, that's
Oh.
because those things pass outside the will. So it is
Okay.
automatic. It goes to the person that you wrote on that paper you want it to go to. Courts are not
Okay.
involved in that.
Okay.
But when you don't do that, when you don't have a beneficiary or a backup beneficiary, then it now becomes a part of your estate. And that means that it then has to go through probate, which takes some time. So you don't get those funds right away and the person you wanted, because on your life insurance, you might have wanted your boyfriend or
Right.
your friend, you know, to have the funds, but in your will, now it's going to go to children or a husband or a mom or a dad. So it may not go to the persons that you really wanted to have those funds.
One of the other things that I see a lot with women when it comes to divorce, they forget to change the beneficiary
Yes.
on their life insurance policies. And if you got divorced and let's say 5 years ago and now you're remarried and you still have your ex on there, ooh,
Yes.
the ex gets that money.
The ex gets all of your money.
So-
and that has happened. I've run into that. I've had friends that have dealt with that. And it's heartbreaking because the family that the person intended to have it now can't have it. And so, again, if you do not change the beneficiaries, it will go to the person. So, of course, in divorce, that's one of the first things you want to do is go and change your beneficiary on your
all
life insurance policies and
retirement
whatever,
accounts.
all those things, so that, you know, whatever family you have going forward or your current family will get the funds and not the ex you
Right.
didn't want
Or
to
your
have
children.
it. Or your children, most definitely.
So those are all really important things. The one last question before we migrate to the next subject is the cost of a will.
Okay.
People think it's really expensive. You just said that you could handwrite a will. I know there's a lot of documents that you can go online and get. But can you just give us a ballpark? Because I know it's different based on your assets, I'm
Right.
sure, and based on your attorney. What kind of ballpark are we looking at if we want an attorney to do a will?
It really does depend on the attorney, whether or not you go to a solo attorney or a large firm or a mid-sized firm. So I would say anywhere from just the will itself, from 150 to anywhere 1,000. And depends on how big your estate is. That's key too.
Okay.
For those that have like a simple estate, house, car, children, small assets, then it should be 150 to 800-900 max.
Okay.
And then when you get into your larger estates, made up of millions of dollars, then it's
Of
going to be
course.
significantly more. But I mean, I would say do not let the cost deter you.
Okay.
Because we pay for everything that we want to pay for. We pay for our Starbucks.
We find
and
the
we get our
money.
nails done and we get our hair done. And those things are important for us to feel good. But we definitely want to leave not only a legacy for our family, but we want to give people peace of mind and give our own selves peace of mind and having those things done. So
And a lot of that is just for women to be more financially responsible, because we talked about it a little bit before the show. Women live longer. Women invest more conservatively.
Yes.
A lot of times the male or the husband figure in the household is the one that takes care of all the finances.
Yeah.
And so we're a little bit disconnected from the actual expenses and the investments and things that are in the house. And if something happens to the spouse, then we are ill-equipped to make sure that we understand financially. And so that's why we spent the last couple of days focusing on women, because we just need to be, I want you to be more engaged in the financial aspects. And it's not just about money. We had a financial expert on last week where we talked about making sure that we're ready for retirement because we live longer. But it's this other aspect of making sure that we have a will. And the other piece of that will is the power of attorney.
Yes.
Talk to us about what that is.
And so what every woman and person out there should have is an estate plan. And that estate plan consists of your last will and testament, your durable power of attorney, your healthcare directive or your medical power of attorney, and a living will. So in terms of your power of attorney, that is the document that sets out who can make your decisions for you if you become incapacitated. And that only comes into effect typically when you are unable to make your decisions. So with the power of attorney, it mostly deals with finances.
Okay.
So it talks about your finances and, your home, your bills, things like that. Who do you want to make those decisions for you when you, are unable to do them for yourselves? It is key to have, because once you need it, it's too late to draft it. So
Right.
if it's something that you need today and you haven't done it, it's too late to then go
Because
in
you
and
have
get
to be
done.
of sound
You have
mind.
to be of sound mind.
Okay.
And you have to have the capacity to agree to allow that person to do that.
Okay.
So even if you're going in for minor surgery, get it done, because some things could happen and you may not pass away, but you could come out and you may not be able to make certain decisions. Your gas and light will go on. Your rent will not get paid because people can't get into your bank accounts
And to write your checks.
So it definitely is an important thing to have. And then also within that document, have a backup.
Yes.
Yes, have a backup.
Definitely have a backup.
Yes.
Because same thing with the beneficiary and the successor.
Yes.
So you talked about a power of attorney, but you talked about a healthcare directive.
Healthcare directive. So that's the document similar to the power of attorney, and often called a medical power of attorney, that gives somebody the ability to make decisions for you when your healthcare decisions.
Okay.
So it only relates to healthcare. It can be making decisions about nursing home involvement, Medicaid, medication, surgery, things like that. Now that one, the power of attorney document is serious, and you want to choose the person that you wholly believe can take care of your finances. So don't choose your favorite son because he's your favorite son, but if he is not good with money, don't choose that one. Choose someone that is good with money and trustworthy.
Okay.
Right? And because that gives that person access to your finances right away. However, with the medical power of attorney, it only comes into play when the doctors really feel like you can't make the decision. So if you can sit there with a doctor and articulate what you would want to have with your eyes, if they're asking for eye surgery and you can say, nope, don't want that eye surgery, then they're not going to give you the eye surgery, even though your power of attorney is sitting right there saying, no, we're going to give her the eye surgery. So long as you can articulate those wishes, typically the doctors will go by what you can. So it really only comes into play when you absolutely cannot make your own health care decisions.
So in today's environment with COVID, we know that a lot of those patients were on ventilators.
That's right.
Those who are nearing death. So that might be an example of, do you want to stay on that ventilator?
Exactly.
Or your family may want you to, but
you may not want to.
You may not want to,
Yes.
and that healthcare directive is going to allow the doctors to make that decision. So most of the time, if you're going in for surgery during the registration process, they ask you, do you have a healthcare directive?
And they'll do what typically is called a living will, and they'll have a general document for that at the hospital. You can also have that drafted as a part of your estate plan. But they'll have the basic forms that will allow you how you want to leave this earth. Whether or not you want to, like you said, be on a ventilator or removed from ventilators, things like that. And that's important, again, because it gives peace of mind to you. but it also takes the burden off your family because you've already decided. You know, a lot of times we
Yeah.
say, oh, we'll just let them handle it. But when you have 6 kids and then they're all fighting over how
Yes.
mom would want to leave this earth, it's hard. It's hard, and it's
Yeah.
not fair sometimes.
And that's a big reason for women, especially because we live longer, because our children, we have, you know, there are a lot of single parent households out there. That gives your children, like you said, well, we know what mom wanted because it's right here. And the other thing that I always said is let your children know
Yes.
what's in your will.
Yes.
And who is the power of attorney, so that they're not fighting over that decision.
Yes. Communication is key.
Communication
And a lot of times
is
we watch
big.
TV and we'll see these movies where they have these big, you know, will reveals, and it's usually because they have millions of
Right.
dollars
Does that
to
really
reveal.
happen?
It, you know, it shouldn't, you know, and it doesn't unless there's a whole lot of money involved. But because those things are not going to happen, you need to tell your family. You may not tell them what you're giving them, but you should say, hey, son, daughter, friend, I have a will. Here's where it's located. And who's, you know, these are the folks that will make decisions for me. Or here's the lawyer that drafted it. Contact them if you need some help. Things like that. You know, don't let it be a secret.
Okay.
Because at the end of the day, they're going to find out, right?
Right.
And you want to let them find out where they can ask questions, and not when you're gone and everybody has questions that can't be answered.
And that all folds back into just making sure that we're educated and knowledgeable,
Yes.
so that we can make smart decisions. And there may be some discussions that might indicate that you need to change some things.
Yes.
So
Most
it's
definitely.
so important. Let's talk about when it comes to the women and the financial wealth with their parents. A lot of us are in that sandwich generation. We're taking
Yes.
care of our children and we're taking care of our parents. And so why is it important for us to make sure that we know a little bit about our parents' estate?
Same thing. You know, women are more than 60% likely to be custodial caregivers for ailing parents or one parent that has now lost a spouse. And so it's important for us to ask questions. And elderly people or older people, you know, do not like to answer those questions. They like to be private. They don't want you to know, one, because they don't want you to start making decisions for them, or they don't want you to put them in a home, things like that. But women have to be on top of that because we are primarily the custodial caregivers. We need to know what their estate looks like. So one, we can help them make it stretch. You know, we can also help them tap into retirement accounts that they didn't know that the other spouse had, bank accounts, things like that. And then once it is time for them to need someone to take care of them and make decisions, those things are already in place. So we have to take on like a double responsibility as women. We have to, you know, care for our children, care for, you know, be prepared to care for parents. And so we need to have the estate plan for ourselves, but then also making sure that our parents have them for that very reason.
Because we need to know, just like we said, our children, we want to make sure that we know what our parents' wishes are.
Yes, definitely be informed.
That's a really, really important thing. So make sure, women, that you are involved. If you are fortunate enough to have your parents still living, that you know what's going on in their realm as well. So we've talked about the will. We've talked about the power of attorney. Is there anything else we need to know about estate planning? I think we've covered quite a bit of it.
Yeah. I mean, just, you know, the key thing is, one, communicating your wishes, but then also choosing people. I see this all the time. You know, not choosing people that are appropriate for the jobs, to be the executor of your will, to be the power of attorney of your
Does it have
finances.
to be a relative?
It does not. It could be your best friend. You could be members of your church. It could be coworkers that you trust. You know, it could be anybody. It does not have to be family. Just someone that you know when you're gone will make those decisions. And the issue with not having a will and having these documents is that we all think that our loved ones are going to do what we want them to do. I get that all the time. I'm not going to worry about it because my sister or my husband is going to take care of it. But, you know, going back to divorcing families and the blended families, I see all the time where a spouse passes away and they go, well, my other spouse will take care of my my prior children. And it doesn't happen. You know, that spouse focuses on their children, and then they don't focus on the others. And it's heartbreaking because I know that their mom wanted them to have certain things, you know, and to be cared for. And so we have to take on the responsibility of preparing for our lives and our families. You know, we can't leave it to someone else, you know, and just because we say that somebody loves us, they do. but sometimes people don't always have the best intentions. Sometimes they come from grief. And that's why, having these documents in place prior to any of that is just essential. Because during grief, it's hard. It's hard to make
very hard.
rational
I've been there.
decisions. It's hard to, so it's just important to do those things ahead of time.
So one last thing before we delve into the career, because I want to know more about the law career, is business owners.
Yes.
How do I fold? I'm a business owner. You're a business owner. How do we fold that into our will? And do we need to, number
Yes.
one, and how do we fold that in there?
Because according to the National Association of Women with Careers, women make up 11.6 of the business world. So they have 11.6 business owners. And so you definitely want to have a will that has a succession plan in within that will, or a succession plan in general, so that when you pass away, who's going to take on your business? Do you want your business just to end because you've ended? Who do you feel like can take it over and run it the way that you would run it, or better? So you want to kind of put those things in place. Otherwise, businesses fail because people didn't have set out, the money portion of it. Who's going to have control of the money to take care of the business? Things like that. So it definitely is most important. Because
now, is that a separate will, or is that a separate document, or are you folding that into your?
You can either fold it into, but you probably will be a second, like an addendum, or a second part of the will that only deals with the business portion. So just a section that deals with your business portion.
Awesome. Now, lastly, before we wrap up here, we have a few more minutes, and I want to talk about your career as an attorney. You said there are 11.6 million women business owners. But we also talked a little bit before the show, and I think there's about 32%, a little over 32% of women who are attorneys.
That's right.
How do I get it? If I'm interested in that, what's that track like from, the education piece?
Well, to become a lawyer, you start with your basics, your high school career, and then college, a degree in college. And that's the thing, people always think you have to go into something specific for a law degree.
Like
you
pre-law
can,
or something.
You can do art. You can do art.
Yeah.
You can do veterinary science. I had a degree, my BA's in psychology.
Okay.
You can do communications. You may want to do something that will help you speak, or, in the communications field, psychology, which helps you delve into the brain, things like that. But it doesn't have to be that, because essentially what you learn in those classes are only going to help you a little bit. Because when you get to law, it's a totally different ball game. So you're going to learn stuff that has no connection to your
undergrad.
So choose anything, to get the BA to move on. So that
How
you
many years of law school?
3 years of law school after college. 3 years of law school. 3 fun years of law school.
Okay. And then you have to take the bar exam.
Yes.
What's that like?
It's horrible. You have to take the bar exam. It's not horrible for everybody, but it can be a very difficult exam. It's going to require a lot of studying, because it's going to hit on topics you learned in law school, but they're not going to tell you what topics they're going to hit on. So you have to regurgitate all of that and know it all in case it's on the test. So it is a difficult exam, but with preparation and prayer and study, then you can do it. You can.
Now I know that only a very small percentage, 3% of Black women are attorneys.
Yes, and we definitely, and that's even seen, here in Louisville. The majority of the attorneys are Caucasian, and the majority of them, I feel like, are mostly male. So it varies from community to community, but we definitely need more Black women, more Black attorneys in general in this field, because the makeup of not only our criminal system, but our family-related issues are African American, or people of color. And so when you're dealing with people of color and their issues, it doesn't mean that no one else can deal with them. It just means sometimes we definitely need that person that has a little bit more insight and can communicate with them in the way that needs to be
into
dealt
our
with.
culture.
Yes, and that knows our culture.
Now, I know that you don't have to take the bar exam. There are a lot of careers in the legal field that, we see when we think of an attorney, we see TV and we see them in the courtroom.
Yes.
But talk about some of the other careers in the legal field that some women might want to explore?
Okay. I mean, women, when you get a law degree, and many people get the law degree to go on to do other things, like becoming law professors or becoming, professors in general. They may want a background in law, but may go teach English, So
Okay.
that it's just, a law degree gives you some technical education that you can use in other areas. You can become a judge. Of course, become an attorney. You can become a mediator.
Okay.
Mediating cases, family law cases, all different kinds of cases. An arbitrator dealing with mostly business and things like that. There's just law enforcement. A lot of people come out of law school with no intentions ever to go into a courtroom.
Okay.
They come out with wanting to go into law enforcement, FBI, U.S. Attorney's Office, things like that. So there's a lot of different avenues.
I have a couple of friends who are paralegals. What's the difference between a paralegal and an attorney?
Well, a paralegal is trained as an attorney. They have, this similar training in that they're able to, they know some of the laws, can do the documents, can, do, legal prep work. They're trained, they're appropriately trained, but they're not licensed. Only attorneys that are licensed can go into court and argue a case, can, go before a judge and, and represent clients. And so ultimately, lawyers delegate certain duties to paralegals, but paralegals can never be in a court on their own, can never argue before a court.
Do they have to have a law degree?
No, not a law degree. So that's another way to avoid avoid law school if you want to if you want to go into the law a little bit but not be fully immersed in it in that sense. Then you could go to paralegal school and get a paralegal degree or certificate.
Awesome. Awesome. Well, thank you so much for being here. I know we've talked about a lot of information. If you have questions, you feel free to email us at info@ssclive.org. Patience Fitzpatrick, if somebody needs to contact you if they want a will or if they need some assistance with family law, have we shared that on the screen? I'm not sure if we did or not. It is on the screen, so feel free to do that. I am Ivy Brito with State Farm Insurance. I'm also available if you need some assistance. I'll be happy to help as well. So thank you again. We will see you next week.
Thank you. Thank you.